Should all of Iowa's children, regardless of their race, have equal access to public education? Should all of Iowa's land, regardless of who owns it, be protected from excessive soil erosion? These were two questions that the Iowa Supreme Court has answered affirmatively. This is Professor Neil Hamilton from the Drake University Agricultural Law Center with today's Our Water, Our Land. I am here at the Judicial Branch Building, the home of the Iowa Supreme Court, to recognize the national leadership that our court has played in recognizing important societal values and how they're protected by our Constitution. This fall, Drake University is hosting a series of events to celebrate the 150th anniversary of the Iowa Supreme Court decision in the case of Clark versus Board of Directors. This courageous decision upheld the right of Susan Clark, a 12-year-old African-American girl, to attend the public schools in Muscatine. The court rejected the policy of the local school board, which said only white children could attend the public schools. The Iowa Supreme Court, in a decision written by Chief Justice Cole, said that under the Iowa Constitution Bill of Rights, all children are equal, and all Iowans are equal. This courageous decision was the first of its type in the nation. Unfortunately, only Kansas followed our lead. It would take over 85 years before the U.S. Supreme Court would reach a similar decision in the landmark case of Brown versus the Board of Education, the 1954 decision that held that racial discrimination in public education was unconstitutional. The Clark anniversary is an important marker in our state's history, but there's another important Iowa Supreme Court decision that we're celebrating an anniversary of this year. 75 years ago, in 1943, the Iowa Supreme Court issued a decision in the case of Benschutter versus Hakes. This 1943 case involved the question of the duties that owners owe to their land and the rights of tenants. The case dealt with the new law that required landlords to provide advance notice of termination to farm tenants. The statutory notice provision, which is familiar to all Iowa farmers, was passed by the Iowa legislature to deal with what they believed were some of the dangers caused by an increase in farm tenancy. The question before the Supreme Court was the challenge by a landowner who said it was unconstitutional for the state to give the tenant an additional year on the land just because the landlord had failed to give proper notice. The Iowa Supreme Court, writing in 1943, used language that would be very applicable to the discussions that we're having in the state today over issues like water quality. The court said, "It is quite apparent during recent years, the old concept of duties and responsibilities of the owners and operators of farmland has undergone a change. Such persons, by controlling the food source of the nation, bear a certain responsibility to the general public. They possess a vital part of the national wealth, and legislation designed to stop waste and exploitation in the interest of the general public is within the sphere of the state's police power. The legislature evidently felt unstable tenure leads to soil exploitation and waste." This ruling made it clear that all Iowans have an interest in how the land is farmed and in controlling excessive soil erosion, which threatens the future fertility and productivity of our land. The Iowa Supreme Court relied on the decision in Benschutter 35 years later, when in a 1979 case, they faced a constitutional challenge to the law that makes it the duty of all landowners to protect their soil from excessive erosion. The court upheld that law and said that the state has a vital interest in how we care for our land, a principle that is just as true today. It's important we recognize it'll take the actions and support of all people. Our farmers, our landowners, our voters, our public officials, and yes, even judges, to see that the soil and water and land that feed us and fuel our economy receive the protections it deserves. We can all be proud that the Iowa Supreme Court has set such high standards for the values and the principles that we will protect in interpreting our Constitution. This has been Professor Neil Hamilton with today's Our Water, Our Land, a production of the Drake University Agricultural Law Center.